Anand, the centre, according to Vrinda Grover, was consulted as per the law. What the centre, interestingly, the Home Ministry has laid down that persons convicted for offences who do not qualify for special remission include dowry death, offence of rape and human trafficking. If I am guilty of rape and human trafficking, then I do not get the benefit of remission. This is as per the June 13, 2022 Home Ministry guideline. And yet this has been flouted. The Supreme Court passes the buck onto the states, and the state government's committee is giving remission in a case of a gang rape, of a woman gang rape, and the people convicted for it, and murder, including that of her 3.5-year-old child whose head was banged and was killed in front of her eyes. Is this a fit case for remission, ma'am?
Rajdeep, I don't know what your real question is. It seems to be a dramatization of sorts. But no, if you look at the law,
yes,
and the CRPC and the Supreme Court judgments, right from Ratan Singh onwards, where it is ultimately a decided issue that the courts have nothing to do with remission. It is the state's policy. And where a matter is of Gujarat, it would be decided by the Gujarat state. The Gujarat state decides the matter in accordance with section 433 and 433A. And that is the decision that they decide to remit after 15 years of sentence based upon the criteria as laid down in their policy. So, I mean, where is the question of dramatizing it to the extent of saying and signifying it as a death signal for some other situations or similar situations? This is case by case. In Radheshyam's case, the Supreme Court asked the Gujarat government to consider it. It was considered. Gujarat government opines itself on remission and releases the convicts. This is the position as it stands.
No,
both on law
that's
as
2
well
points,
as
ma'am. I just want to ask you 2 points. One, are you saying that the Supreme Court has no overriding powers? If you recall, the Gujarat High Court had rejected the plea of Radheshyam, who wanted remission of sentence, saying we are not going to do it. Then Radheshyam goes to the Supreme Court, and the Supreme Court says we'll allow the Gujarat government to review it. So, could the Supreme Court, ma'am, in your view, have had overriding powers and said this is a heinous, serious crime, we are not going to allow remission? Could they have said that, yes or no?
I believe not. I believe not. I believe the Supreme Court is bound by its earlier judgments as much as Ratan Singh and the entire series. And as Vrinda rightly said, it is as per the statute as prescribed.
Yes.
So the question is, the statute itself gives the part of the state government in this particular case, which the state government is exercised. So the overriding powers of Supreme Court cannot come in to say you can't do it. It can tell the government to consider it, can tell the government to review it, but it cannot tell the government you either grant remission or you don't grant remission. It is clearly a matter of state policy until such time as the law stands.
But where does that then leave these guidelines that the Home Ministry has put in place, saying there are certain crimes where you cannot have remission? So within a year of that, you got this case. Now you're saying it's case by case, but this will be used, ma'am, as a precedent tomorrow by other state governments and, dare I say, by other courts. Doesn't that worry you that even a gang rape and a murder of this heinous kind will now become a precedent?
I'm afraid, Rajdeep, that wouldn't be correct. You can't say it will be a precedent for any state. Every state has its own policies and will exercise them in accordance with their policy. So if a state, for example, has a policy that it will not be granted in case of gang rape, and the policy, incidentally, Rajdeep, as you were quoting, you're talking about the centre's policy of June 2022. That is not the policy in any case that would govern. The policy which clearly the Supreme Court has laid down is the policy that will govern the accused at the time of conviction and not now. So in any case, you can't bring in the centre policy to say that that is what would govern. You are right. We need to have this message constantly that you cannot have any disregard for women. You can't say this will be a precedent for any other state. It is an individual state's policies as they determine it and they exercise it. And the Supreme Court asked the government to consider it. It's not as if it came out of the blue. Right. It is on Radheshyam's petition that this entire matter went to Gujarat for consideration under the 1992 policy, which is a prevalent policy which is relevant.
So you're saying the Supreme Court had no option. In your view, Supreme Court had no option.
Yes,